Right. So this is as we mentioned, this is the second of our series for the landlord basics, and the topics we're covering today is about lease termination, pests, and mold. And so, thank you for joining us again. Just before we get started, just our usual disclaimer: you agree by participating in this webinar that the information presented does not constitute legal advice and is being presented for informational purposes only. We agree that no attorney-client relationship is established or assumed by participating in this webinar, and that the information or suggestions presented in this broad overview may not apply to your specific circumstances.
Hi, I'm Ashlee Adkins. I'm one of our associates here at the law offices of Peter Brewer. I handle a lot of the commercial and also residential landlord-tenant issues. Today, we're going to be talking predominantly about residential landlord-tenant law. And here is my colleague, Henry Chuang.
So I'm Henry Chuang. I work in the secure lending and the landlord-tenant residential real estate aspects of the firm. I handle most of the landlord-tenant disputes and any of the lease issues and any of the foreclosure litigation. And as I mentioned before, earlier this year, we already did part one of the landlord basics. And if you have any questions about that, or if you want to watch it, we do have it on our website. So just go there. It covers a lot of the introductory portions about forming leases and cover some of the issues then. Now we're going to actually focus on, once the leases have been formed, how do you terminate them? So that's going to be my section at the beginning. There are a couple different ways for leases to actually be terminated. The easiest one is going to be on fixed term leases. The fixed term lease, and you will see what we have as an example, is going to be, if you have a lease that starts, typically it's going to be 1 year. So say January 1st to December 31st. As if on the fixed term lease, at the end of that term, it will expire as part of the contract. So on December 31st, the lease expires because that's what the contract's agreement says, and that's what the parties have agreed to. You don't need to give any further notice unless the contract itself says you do. So if you have a December 31st and you're using the standard CAR form or PRDS form, most of those forms don't have a notice provision. So you don't need to say 30 days before or 60 days before. You don't need to tell the tenants you're not planning to renew, and the tenant doesn't need to tell you they're not planning to renew. It's just assumed to end on December 31st. Now, although as a matter of the contractual rights, you don't have to give a notice, we strongly recommend as best practices that you do talk to the tenant. You don't want to be surprised that the tenant's not renewing. You don't want the tenants to just move out on December 31st and you thought they were staying in. We always encourage communications. In addition, as a matter of law, as a landlord, you're required to give tenant notice that they're entitled to an initial inspection. So this initial inspection is basically trying to deal with the security deposit and to give the tenant time to work out what, or to make any repairs that you believe you're going to take deductions for. So when you're walking through, you need to point out, say, oh, there's a hole in the wall here, there's this, crack in the window that, you chipped or whatever, and that these are things that as part of the repair of the property, you're going to deduct from the security deposit. And once you notify the tenant of them, they get a little bit of time to make the repairs, and that has to be done before they move out. And so that way they don't have any deductions from the security deposit. Relatively straightforward. Now, although the fixed term lease expires at the end of the term, the law does provide that if you accept rent from the tenant, then the lease automatically converts to a month-to-month lease. You'll see in many leases they address this also, but as a matter, even if it's not in the contract and it's not in the lease agreement, as a matter of law, once you've accepted rent, it does convert. So say January 1st, December 31st, and then January 2nd or 3rd, you accept rent for the next year, for that month and the next year, then that converts automatically to a month-to-month lease. And then different rules apply at that point in time. So, like I said, in a fixed term lease, if the lease is going to expire, as we said, we would think the best practice is that you want to talk to the tenants, usually 60 or so days ahead of time, saying, what's the plan? And if you do reach an agreement and everybody wants the tenant to stay, the landlord and the tenant both want them to stay, then we would say that you should draft a new lease. This is not required. As I just mentioned, the lease will automatically convert to a month-to-month, so you technically don't need to do anything. And we've definitely seen clients who didn't. I think the most interesting example is that we had a client who had a lease from the 1980s that was a fixed-term one-year lease, and it never got changed. We certainly don't recommend that because typically situations will change over the years, and so we suggest drafting a new lease each time, if for no other reason than the fact that you have to look at the terms to make a decision on what you want those terms to be. The biggest issue about this is typically change over time. And as you're well aware, if you had a lease in 2012, rents have increased dramatically since 2012. And so what we've seen from a lot of landlords is that they will have leases that are relatively old, long-term tenants, and they've never raised the rent. And so after 5 years, they've realized they're 30, 40% under market. And instead of having done this gradually so the tenant could afford it, they now raise the rent by 30%. And that's basically going to be the tenant leaving because they can't process and budget for such a large increase over a short period of time. But if you're doing this gradually and you're having a small increase every year and you're looking at that, then we can, they'll be able to prepare for this and you have a better relationship with the tenants. So just as a best management practices, that's what we recommend. And this forces you to discuss with the tenants to see what their plans are. It helps you look to see if there's any terms you're going to change, like the number of keys you're providing. If you have a large group of people living there, whether any of the tenants have changed. So a lot of times, especially in Palo Alto, where we're located, much of the housing is for Stanford students, and many times people will live there in groups of 5 or 6, and the students will change on a yearly basis. But if you're not updating the lease every year, you don't know who's going to be there. I mean, technically, you have that list, but if you let them go on, that could become a problem. Now, if you don't want to go through the hassle of creating a new lease every year, most of the standard form providers, such as CAR and PRDS, do have short forms and addendums for lease renewals. And those typically are just one page and cover the key terms. So they'll cover the issues such as what is the change in rent, what is the change of the term of the lease, and then talk about the security deposit. Do you want to increase that? So as we talked about in formation, you're entitled to get 2 months rent of security deposit. Well, if your rent has increased, then that security deposit can also increase. But if you haven't really thought about it and just increased the rent without the security deposit, you could have problems where the security deposit is insufficient to cover the rent or any other issues that happen when the tenant does eventually leave. So when you do these renewals, instead of going to the month-to-month, we really do encourage looking at these lease renewals, drafting either at least the short form addendum to make the change, or better yet, drafting a new lease each time. And so we have couple graphics to go over kind of this as an example. So as I mentioned earlier, on a typical lease, if it is 1 year long from January 1st to December 31st, it terminates on its own. This is very similar to any other contract. So if you had a contract, for a cell phone for a month or however long time, it automatically just terminates at that point in time. That's what you've contracted for. That's what the parties have agreed to. Unless there's a separate provision in the rental agreement, that's just what's going to happen. And so what's the best practices is that prior to the termination of the lease, prior to December 31st, you are required as a landlord to give notice to the tenant that they're entitled to an initial inspection. And that's, as I mentioned, is to help with the security deposit resolution. And that prevents future litigation. Now, if there is going to be a renewal of the 1 year lease, you're keeping tenants hopefully for multiple years, then you just want to draft a new lease each time, or you want to create at minimum that addendum that addresses those key points of, here are going to be the tenants in there, here's going to be the length of the new lease, here's the amount of the new rent, and then here's the amount of the security deposit, and any other changes to the terms. So sometimes we'll see people say, yes, and you can now have a pet, and you address that portion in it. And then if you don't do any of that, but you continue to accept rent, then it becomes a month-to-month tenancy. And that's an automatic conversion. Typically, as I mentioned, it's in the contract itself, but it's also a matter of state law. Now, if you don't have a fixed term lease and you're in a month-to-month, either because of the conversion or that's just what you had agreed to originally, there are different notices that you're required to give depending on how long the tenant has been in the property. So from the landlord side, if the tenant has been there for less than a year, the landlord can give 30 days notice. Now, if the tenant has been there for longer than a year, the landlord has to give the 60-day notice. As we just covered, as we mentioned before, there's a misconception that these notices are required even on a fixed term lease, which is not actually required unless your lease provides for it. However, on the month to month, these notices are certainly required. You don't need to give any reasons for the termination as long as it's not discriminatory or retaliatory. These can just be given as to, you're just saying that we're moving on. This is because the contract has terminated, and that's why it's a month to month. Now, let's be clear. Today's discussion and everything we covered today is just the general law and not for a rent control district. Many different cities have rules that talk about terminating leases and restrictions on that. So as many of you probably are aware or heard about, San Francisco has a just cause ordinance. And there are many new jurisdictions who are looking at this too. So Mountain View just has new rent control and just cause ordinances in place also since the last election. There's litigation ongoing, but just be aware that if there is a just cause ordinance, and if there's rent control, that may change the right to terminate a lease and the right to increase rent. And that's something you're going to have to look at, and it's going to be a jurisdiction by jurisdiction basis. We're not going to cover that because we just don't have the time to go into that detail. But if that is an issue for you, look at that before you give the notices to terminate. Now, on the other hand, for the tenant, regardless of how long they've been in the property, all they must give is a 30-day notice. It doesn't matter to them if it's going to be, they've been there for less than a year or been there for more than a year. And then, regardless of who gives the notice, the landlord's required once that they've received the notice within a reasonable time, or once they've given the notice, within a reasonable time, they must tell the tenant that they have a right to that initial inspection. So that's going to be the same initial inspection as if you terminated the lease pursuant to the fixed term. So just to give you a little bit of chart, kind of summarizes what we've discussed about the 30 or 60-day notice provision. Now, what if you want to terminate early, and what if that's kind of the goal? So oftentimes we see this, if it's going to be on the landlord side, it's typically because they're trying to sell the property. Just as a special note, landlords are entitled to get access to the property to show it during normal business hours, but they are required to comply with California law, which is typically notifying the tenant that the house is going for sale, and then that they have to give 24 hours notice to enter the property. And so if a landlord wants to terminate early, typically what we see is that, and what's required is that they need to reach an agreement with tenant, because you can't just terminate a contract without some sort of agreement. And so oftentimes we'll see landlords work voluntarily with a tenant in either agreement to leave early because the tenant doesn't want to be inconvenienced, or that they more often than not offer some sort of buyout to get the tenant out faster, because a lot of realtors prefer homes to be empty so that there aren't any possible issues with the tenant not being a particularly great tenant when potential buyers are coming in to look at it. And so this is going to be a negotiation between the landlord, the tenant, and whatever they agree to. And those terms can be whatever the parties do agree to. On the other hand, if a tenant terminates, what they're going to do is likely abandon the property. And once they abandon the property for whatever the reason, they bought a house, they want to get out because of, they're moving, a job change or whatever. Once the tenant does breach and leave early, they can do the same thing as the landlord and try to reach an agreement. But if they don't reach an agreement as to that, then they're going to be in breach of the contract, which entitles landlords to damages. We've had a lot of tenants come in and say, well, we breached this, but they're at most entitled to just 1 month's rent. That's not actually correct. Technically, under the law, the landlord would be entitled to whatever remaining rent is in the contract. So if you have a 1-year lease and you've lived there only for a month, they would be entitled for the rest of the year of rent. Now, so whatever that portion would be, if you've only been, if you've been there for 11 months and there's only 1 month left, they're entitled to their contractual benefits, and because of the breach, they would be entitled to damages. Now, what does at least in hopes to mitigate this, is the fact that the landlord has a duty to mitigate. What this means under the law is that the landlord has a duty to try to re-rent the property. And so if, obviously if you have a circumstance where there's 11 months of rent that's still on the lease, if they can re-rent it, they have to at least try to re-rent it. And then if they are able to, those damages are reduced. So what we see is that if the tenant breaches, say in September, and they're able to re-rent to somebody else in November, then the damages would be just capped between that September to November period, unless there's extra damages because a new rent is lower or whatever. But at least there's some sort of mitigation, so the tenant wouldn't be on the hook for everything. But that's what we see from that's a question that does come up a lot where tenants do want to leave early, and so there are going to be contractual damages that the landlord would be entitled to. Now, we discussed earlier about voluntary breaches or voluntary terminations of leases. What happens in an involuntary period where basically the landlord's trying to get the tenant out or the tenant is forced out for reasons that aren't permitted in the contracts? The most common one that we're going to cover today is going to be the failure to pay rent, right? That's the one that most unlawful detainer cases cover. The tenant owes rent, doesn't pay. And so as a landlord, what you're required to do is to give a 3-day notice to cure, basically pay rent or quit the property. And you've probably been familiar with these notices, but basically in the notices, they do have strict requirements as to comply with what the rent calculations are. You're entitled to put on the 3-day notice that, this is the amount owed, but you're not entitled to do extra. So make sure then that you're putting there is correct, because the courts are very strict on this. It doesn't mean you're not entitled to those other fees, they're just not entitled to be put there as a 3-day notice to pay rent. And then if the tenant does not make the payments, landlords are not entitled to self-help. And I hope that you guys all know this by now, but there's no right of the landlord to do what they want to do. They have to go through the eviction process and get a court order for possession of the property, and then to have the sheriff serve the possession of that rate. And we don't have the time to go into details. That's probably going to be another seminar where we cover the specifics of eviction and what's going to happen in the actual court process. But just to let you know that there is no self-help. Landlords, even if the tenant doesn't pay rent, it doesn't mean the landlord can go ahead and take action directly without involving the court in that process. Now, there are other contractual requirements, and so if the tenant is in breach of those other contractual obligations, then you can send another notice to them for them to cure it. You can do a 3-day notice if you want, to cure for most violations, but in some very extreme cases, you can do a 3-day notice without cure. If you're going to do that, the courts do look at it in a very strict manner, so we strongly recommend that you talk to an attorney to see if the violations that are occurring are sufficient to justify a 3-day notice without cure. And then once those 3 days run, if there has been no cure or no cure has been permitted, then you're going to be very similar to the failure to pay rent, and the eviction process will begin. Once again, California law doesn't allow self-help. Now, on the other hand, if the tenant feels like they've been wrongfully evicted because of other issues, they may be able to claim that there's been a breach of the contract by the landlord. And typically this occurs when there's going to be a warranty of habitability issues. And so that's going to be the pests and molds and other damages that we're going to cover in a little bit, and Ashlee will take the lead on that portion. Or also another one is that it's going to be the covenant of quiet enjoyment. This means that typically when a tenant leases a property, as part of that, they get to lease the property and they get to lease it free of any interference from the landlord. And that includes, the landlord can't just come into the property because they feel like it. That's not permitted unless there's some special rule in terms of the access. So if they're showing the house, for sale, then the landlord is entitled to access as permitted, but they're not entitled to do that as just because they feel like going in. And if that happens, that may rise a level of an eviction of the tenant that wasn't permitted. And so then the tenant would have rights and may have claims for damages at that point in time. Now, what happens if the lease expires or the lease ends and the 3-day notice or your 30 or 60-day notice has run and the tenant doesn't move out? That's what's called a holdover. Once if the tenant keeps possession past the termination of the lease, they are now holding over. As with the other notices, you still have to go through the eviction process. You can't do any self-help, but at least on the Palo side, if the lease has terminated on its own, so December 31st rolls around, on January, there was no renewal, you didn't accept rent, on January 1st, then you can go ahead with an unlawful detainer proceeding. You don't need to give another notice saying, oh, this other notice, the original notice or the original lease had already terminated, because that's at that point in time, it actually had terminated. So for example, if you give a 60-day notice to the tenant that the lease terminates, and beginning on February or March or whenever you have that, then it just terminates on that date. There's nothing else that you need to give notice on. And so you're not entitled to change the locks. You're not entitled to turn off utilities. Those are all self-help measures that would cause landlords to suffer, that could have claims against the landlord, but you are required to go through the court system and to get the unlawful detainer and get rid of possession. Now, what happens if the tenant abandons the property? So this is one that has occurred sometimes, where typically we saw this a lot, several years ago when there's tenants who just disappear. And if that's the case, California law does provide the landlord the option to go through a notice of belief of abandonment. And the reason why people will look at this and do this is because if you successfully complete this and meet all the requirements, then you can take possession without having to go through the unlawful detainer process. And in order to do this, you have to give a notice, and there's a statutory form that gives you the language you need to include. And so you can say, here it is, and you must give 18 days minimum notice for the tenant to respond to say that they didn't abandon the property and whatever. But if they don't respond that time, then you could go and try to get possession back. And now this option is only available if rent has been due is already 14 days late. So if you're going to do this, I would suggest consulting an attorney because it's relatively straightforward, but there are a lot of specifics. But go ahead and talk to them about it. And then if there's any dispute, you need to have factors showing that there was abandonment. So if you happen to go by and you see the property is empty, if when you take over the property, you see that there was all the personal belongings are gone, or if you were notified that utilities were cut off because the tenant had shut down the account, those will all be factors that the court will look at in confirming that there was a reasonable belief of abandonment of the property. And now I'm going to turn it over to Ashlee to talk about specifics as to some of the habitability issues that we do encounter.
Hi. So if you were a part of our part 1 landlord and tenant basics webinar, you would remember that I talked about habitability, but I only talked about it at a surface level. And in that webinar, I discussed a California Supreme Court case, Green versus Superior Court. In that case, the court gave landlords an implied warranty of habitability, which basically gave them the duty to maintain their residential unit with a certain set of conditions that make the unit habitable. Now, the court and state statute are vague in this area. Civil Code Section 1941.1 lays out baseline requirements that a unit must have. Those include heat, locking doors, hot water, that type of thing. But as far as what habitable is and what it isn't, judges have a lot of discretion to determine this. And as you will see, the defects we talked about today, they usually end up in court. And so that's very important when you're a landlord and also a tenant, is to consider how the court is going to be against you. For landlords, for example, the court's really tenant friendly, and so it's really important to address issues right away, because if it does end up in court, cards are stacked against you, so you just want to keep that in mind. So why are we discussing mold, pests, and water damage? Well, first off, we had one of the most rainy seasons in California in recent history, so we presume that there's a lot of issues going on with this type of defect in your residential units, including mold and flooding and leaky roofs. Also, the remedial measures of these types of defects are much more severe. The tenant has at their disposal a lot more significant remedies, and I'll discuss that later on. Also, There's faster response times required. Typically, the law requires 30 days. That's a reasonable amount of time to fix a defect that makes a unit habitable, but with mold, pests, and water damage, it's typically less. For example, flood would be, you got to fix that within 24 or 48 hours. So it just really depends on what defect it is and what the reasonable standardness is. So for mold, the most important thing that a landlord should keep in mind is the health effects associated with mold. As some of you may know, common side effects are asthma, respiratory problems, and even skin conditions like eczema. This is important to keep in mind because not only would you have damages for the tenant for rent and other damages associated with the lease, but also you could be liable for health damages if you don't address it right away. We get a lot of calls and people ask what's toxic mold and what isn't. In 2001, the Toxic Mold Protection Act came into form, and they gave states the power to set the permissible level of mold for residential units. And as you can expect, as the case law and statute shows, the California Department of Health is quite vague in this area. They give certain criteria for how they assess mold and what's a health hazard and what isn't, but there's really no clear line on this is toxic and this isn't. It's really based on the effect it has on the tenant, but the standard they gave for the permissible level is based on the most sensitive tenants. These include children, people with pre-existing conditions like asthma, and seniors. So you really have to be mindful as a landlord that the law is in place for the most sensitive people, not people that aren't as affected by mold. So you really have to be careful with that. Next slide. So when are you responsible as a landlord? I would say about 90% of the time, but that's not certain. Usually the court is going to deem you liable unless the tenant was totally unreasonable. These include failure to remediate a known issue. So if the tenant calls you and tells you, hey, there's mold in our bathroom, and you just kind of put it to the side and don't address it right away, you could be liable for damages from that. Failing to fix leaks. So if the toilet's leaking, under the kitchen is a real common one we get. That mold under the sink, and they probably don't see it right away. So you want to do maintenance on your own because you can't rely on the tenant to tell you everything that goes wrong. And you'll still be liable even if they don't tell you and it ends up being an issue with upkeep by you. And as mentioned, it's very important to address right away. It accumulates and spreads very quickly. So what might be an issue, just a nuisance in the beginning, a mold in the bathroom under the sink, it could become a real issue later on if you don't address it. And again, courts side with tenants, and so if you decide to neglect a mold complaint or an issue in your unit, you're going to end up in court and you're going to end up paying triple the amount you would pay to remediate the issue from the onset. So like I said, unless the tenant is completely unreasonable, you're going to be liable as a landlord. Examples that we've seen include poor ventilation. Now, that could be a failure to maintain by you, but if you are keeping your property in good condition, they fail to use bathroom fans, open windows, or really close in the unit and cause a lot of moisture not to get out, they could be liable there. But again, it's going to be up to the judge, and you have to keep in mind their bias towards landlords. Failure to maintain a level of cleanliness. A lot if you have students, people, young tenants. I don't know how much they're going to be cleaning the bathroom or under the sink, so you really have to keep care of that and keep note on it, because if they were responsible and didn't clean the bathroom, you would be able to protect yourself. But that's something that, again, the court is going to have to determine. Some humidifiers can cause mold. Again, that's really up for discretion and just negligence by the tenant. If they leave wet towels on the ground or cause moisture to accumulate in areas that it shouldn't. So habitability, in January 1st, 2016, Senate Bill 655, added mold to the list of conditions that make a unit uninhabitable. So as discussed in our first webinar, Civil Code 1941.1 gives a list of certain conditions that if they're not present, they make a unit uninhabitable. Mold is added to the list, and you cannot have that in your unit. As mentioned before, there's certain repair requirements now. If mold is in the unit and you're made aware of it by your tenant, you're required to repair fairly quickly, both due to the health effects and also it could damage your property. And so cost coverage here, that's probably what landlords are most concerned about because it can really add up. But typically, the procedure is that you put a tenant up in a hotel, you get an inspector out and they remediate the mold. And they say, oh, do I have to cover hotel costs? Does a tenant pay rent? Typically, yes. Some city ordinances require the landlord to pay hotel costs. Again, this has to be reasonable. It can't be for 2-3 months, but typically you put the landlord up in the hotel for a couple of weeks, you remediate the issue, and they move back in. That's just part of it. It's part of being a landlord and something that you have to consider. And then a lot of calls that we get regarding mold, the landlord asks, does the tenant pay rent while I'm fixing the mold issue? Short answer is no. Typically, if they're up in a hotel, they're not required to pay rent because arguably they're not using the premises. The safest way is just not requiring them to pay rent because in the long run, they may take this to litigation and be able to recover their rent anyways with remedies that I'll discuss later. So you just want to make it as easy as possible on your tenant, and it's really the best practice to put them in a hotel because it's not really safe to remediate mold with a tenant in there. And you could probably do it a lot faster with them out of the property. So now on to water and floods. As mentioned, Civil Code Section 1941.1 says these defects are, they make a unit uninhabitable. Common causes are leaky roofs, broken pipes, especially with the roof damage this winter. If there's any sort of defect in the roof, I'm sure you've heard about it. We had an awful lot of rain, and there's probably a lot of issues going on right now of fixing that you should address rather quickly. So liability for flood damage duty, as with mold, usually falls on the landlord. Again, California courts are very tenant friendly. And just like with mold, unless the tenant does something completely unreasonable, you're probably going to be liable. We've had clients come in where if they left the shower running or they didn't let water drain out of the bathtub, kitchen sink, something like that, then the tenant's probably liable. And most of the time, as a landlord, it's going to be your duty to fix it and to pay for the costs. And then again, in our first webinar, I discussed what a tenant must do in order to be able to use different remedies disposable to them. Again, they have to use plumbing properly. Like I said, you can't leave a shower running. You have to let water drain in its proper way. They can't reconstruct the property. If they try to repair the roof on their own or modify the home or the apartment, that's going to put them liable if there's flooding. Also, they have to use the premises for its intended purpose. If you rented the premises to them as for residential reasons and they're using it for work or a retail operation, that's going to put them liable if there's issues with that. So available remedies for both mold and water damage. I've talked about it before. There's also an article on our website on the repair and deduct remedy. This remedy is likely not available if you're familiar with the requirements. One of them is they put a cap on this remedy that you can only use it twice a year, and the cap is at 1 month's rent. So say if the tenant's roof is leaking and they want to fix it, they're capped to that repair to 1 month's rent. And even in this area, when rents are high, it's probably not going to cover the repair of a roof or flood damage or mold remediation. So that remedy is likely not available. And again, these are only available to a tenant if the landlord fails to act. So if you remediate the issues right away, you don't even have to worry about these, and it's really going to save you a lot of money and the tenant a lot of trouble as well. So in these severe situations, the likely remedies are abandonment and withholding of rent, and I'll discuss those in a little more detail right now. For abandonment, my colleague Henry discussed that slightly, but from the lease perspective, but when something actually does go wrong, this is available for your tenant when you fail to fix the problem. And again, it's only available when the repairs are more than 1 month's rent. And the requirements are similar to the repair and deduct remedy. These include that the defect has to have impact on the tenant's health and safety. The tenant could not have caused the defect. They gave the landlord notice, and the landlord had a reasonable amount of time to repair. And again, you'll see in the code and case law that you have 30 days to fix, but you have to address every issue differently. So for flood damage or severe mold or infestation of pests, you probably don't have 30 days. For flood, 24 to 48 hours. Mold, maybe not as quick, but certainly less than 30 days. Same with pests. So you really have to keep that in mind, because the tenant's going to have to act quickly if you don't. So for withholding a rent, again, this is when the remedy would cost more than 1 month's rent. And actually, in the Green versus Superior Court case I mentioned in the beginning, it's a 1974 California case, they gave specific instances when withholding a rent was permissible, and so you can follow that. And some of those defects include the bathroom ceiling collapse, the continued presence of rats, plumbing blockages. Those are all instances where the court said, okay, if you withhold rent for that reason, when the landlord doesn't fix the issue, that's okay. But again, both with abandonment and withholding of rent, these matters usually end up in litigation. So as a landlord, you really want to jump on these issues because one, you're going to be out a substantial amount of money, both rent and then fixing the property, and also you're going to end up in court, which isn't cheap for anybody. So if you do end up in court because your tenant withheld rent, or as a tenant you kept rent because the landlord didn't fix the property, the judge has added discretion to formulas. And again, as a side note, as a tenant, if you do decide to withhold rent, I would not spend that. That's just precautionary advice, because you're going to end up having to pay something. If your rent's $3,000 a month and you withhold $3,000, you want to have that at your disposal down the line, because you're more likely going to be brought to court by a landlord, and the judge is going to say, hey, here's the fair amount you pay. And by deciding that, he has two methods. First is percentage reduction in rent. So the judge will look at the defect. So say if a bathroom ceiling caved in and there's 4 rooms in the property, that's one of them, you might be required to pay 60% rent, 75% rent. It just depends what's reasonable. So you can go by percentage, and your rent will be deducted by that. Another method is reasonable value of rent. So they'll look at the market value of rent for that unit, which is actually usually based on what the lease says, and they'll deduct the amount, the value in defective state, and you'll pay the difference. So again, as a tenant and a landlord, we don't really want to get here. Even as attorneys, we're here to help you with those types of issues, but we would prefer if you didn't have to expend that amount of money and handle it outside of court. But again, we're here to help if it gets there. But as a landlord and as a tenant, these issues can be handled much earlier on if you're reasonable and act quickly. So now on the bedbugs, there's an assembly bill passed recently, and what the bill did was require that landlords give all prospective tenants on or after July 1st, 2017, notice of information regarding bedbugs for the unit. And this doesn't just happen if there's bedbugs in the unit, you found them. This is for all prospective tenants, bedbugs or not. So this is really important. And as a landlord, as a tenant, you should know that as a tenant, you'd be getting the information, and as a landlord, you have to give this information. And to assist you with this, we actually provided a form on our website, and you'll see the link below at brewerfirm.com/bedbugs. Now you can just fill that out and give it to your tenant for anybody that would be moving in on or after July 1st of this year. And the bill didn't just require that form, they also require that the duty for a landlord to respond to the issue. And also, if you receive a complaint from a tenant regarding bed bugs, you can't retaliatory evict them within 180 days of the complaint. So that's important too. It gives tenants a little more confidence to tell you there's an issue without the fear of the landlord coming back on them about it. So that's just a brief overview of bed bug law that's changed recently. And all those defects: mold, water damage, and bed bugs. As you can see, the common theme is react fast, and both sides will save a lot of money. And so now, if we have any questions, we can address those. And we're going to look on our chat to see if we have any questions.
Along with the bed bug portion, we do want to note that this year, as usual, we did create a new new laws handbook, and in one of the new laws that we do cover is going to be the bed bug laws. So we did get a question about what the advantages of going month to month are. So yes, one of the advantages of month to month is flexibility, and that you can change the terms of the lease if you give the proper notice. There are different notice requirements depending on if it's a rent increase and if the rent increase is above 10% or not. So that does give some flexibility, but there's also a downside of flexibility because the tenant can give notice to terminate, right? So if you want to confirm that they're going to be there for another year, because oftentimes 30 days from a tenant's notice is not going to be enough to find a new tenant, then that could cause some problems. And so that's why oftentimes a lot of landlords prefer not to have a month-to-month tenancy, because that leads to an increased chance that there's going to be a vacancy because you just don't have enough time to respond. And then another question we've had was about the repair and deduct. So there is a limit about that, and basically you can use it twice and within a 12-month period of time. I forget if it's specifically within a calendar year or 12 months, but I think it is a 12-month period of time.
Yeah, within 12 months you can use 2 months worth of rent, but the structure of that is for if you had a defect in January, you can use that month's rent to fix it. You can't combine January, February rent into one and fix it that month. You could use it 2 separate months. It could be consecutive months if you like, but it has to be separate, and it could be twice per calendar year.
And then another question we had was about the security deposit and increasing the security deposit on the renewal. You're not required to return the security deposit to collect it again. It's just not really, that's just kind of an impractical solution. And we would just say that if you're increasing the security deposit, and if you do use another new lease, you'll see in the form, typically, at least in the car form, here is what amounts you've already collected. And you can note in the collection that you actually had $4,000 from the original lease amount, but $5,000 is owed. So by the signing of the lease, they need to pay X amount. And so that's kind of how we would address that.
And someone asked if there's a YouTube video available of part 1. There is on our website. If you go to resources, we have that on there as a YouTube video. You can review it. You'll see that it links heavily with this part 2. And we can also send that via email to the people that viewed this webinar today. We can send you the prior YouTube video, and then this one will be posted as well later on.
Yeah, and we will make a short apology. We did have technical problems with the original landlord-tenant basics. Although the audio, as I understand it, the audio does come through for all of it. I think there's going to be a period of time, mostly when Ashlee was speaking, where the video did not come through. And so, although it is all going to be there, but otherwise that video part may not be available. So we're getting close to the end of the hour. We really thank you for attending. Like I said, if you have any topics you want us to cover, please shoot us an email. We're doing this because we're trying to help you guys out with issues that you are interested in, and so we're certainly interested in providing coverage over topics that that are coming up for you guys. What we've picked are the major ones we think are most important, but if there's specifics that you guys want to cover, we're certainly happy to do that.
Yeah, we're always open for suggestions. We try to stick with what's going on at the time, so you're well equipped as a landlord and a tenant. But again, things come up. There's always issues going on when you rent a residential unit and when also you're a renter. And so we're here to help whenever you need it.
And then there was one person who just sent in a question about Airbnb and addressing that issue. We have done a seminar or a webinar on that. Simon Offer did one previously, and that should be on our website also. I believe we've written a couple articles about that issue too, so that's certainly on our website. You can look at that. We do provide resources on it, and if you shoot us an email, we can send you the link. But I think it's under I think there is a link on our website, and it's about that Airbnb and the webinar on it. But once again, thank you so much for attending. If you have any questions, please feel free to shoot out email to us. All right. Thank you.
Thank you.